seated.
Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome to Talk Law Radio. I'm Todd Marquardt on KLUP 930 AM The Answer in San Antonio, Texas. This is going to be a great show today. The hidden legal issue blind spot is Texas Senate Bill 29, which is a new law that became effective May 14th, 2025. It's something directors, officers, and shareholders of businesses need to know about. Before we get started talking about the law, let's begin with prayer. Dear God, thank you for this day. Thank you for all the gifts and blessings that you give to us. Please forgive us of our sins, for our mistakes, for doing the wrong thing or failing to follow your will. Please help us be good stewards of the resources that you provide us by learning about this new business law today. Help us to use the gifts and talents you've given us for the good of your people, for our own good, and for your glory. In Jesus' name, amen. Now it's time to discover your legal issue blind spots by listening to me talk about the law on the radio. The Texas legislature just finished its regular session. Of course, it's already in a special session, but for the regular session, the legislature passed and the governor signed some new laws. And one of the new laws is Senate Bill 29, which includes codification of the business judgment rule. I'm going to talk all about that and let you know. There were other business laws that were passed that I might be talking about over the next few weeks. Senate Bill 346, which concerns business filings, that allows for expedited filings for businesses and makes veteran-owned businesses tax exemptions permanent. House Bill 2464 relates to home-based businesses and prevents cities from imposing regulations on certain home-based businesses. Also, House Bill 5195 is regarding state agency website modernization. So we'll address these new laws in the weeks to come. Senate Bill 29 covers lots of different things, but we're going to focus on the business judgment rule. And so I thought you might want to know, what is the business judgment rule? Well, since 1878, for the last 147 years, businesses have relied on case law, court cases, to resolve shareholder disputes using the business judgment rule. The rule protects directors from liability for honest, discretionary decisions made in the corporation's interest, even if negligent or imprudent, absent fraud, bad faith, or gross negligence. It's really defensive in nature. So what usually happens is the business gets sued by some of its shareholders, or maybe even one shareholder, and the officers and directors have to defend themselves by saying, we did that for a business purpose using business judgment. And even though it didn't turn out the way you wanted it to, it still doesn't mean that we did anything wrong. Well, to make it more attractive for businesses to come to the state of Texas and to innovate, the Texas legislature wanted this case law to be on the books, to be written into the Texas Business Organizations Code, so that you don't have to defend yourself in a lawsuit every time somebody gets upset with you. Now, the most common occurrence when this business judgment rule comes up is in what they call a derivative lawsuit. That's when a shareholder claims that the business itself needs to file a lawsuit against one of these directors or officers. The shareholders are trying to sue on behalf of the corporation to allege breaches of fiduciary duty. But the rule protects these officers and directors unless plaintiffs can prove fraud, bad faith, gross negligence, or self-interest. I'm going to talk about some examples of when this comes up so that if you're a business owner or you're a shareholder, you'll know what it looks like. Like I said, this has been going on since 1878, these court cases. And so if you ask lawyers, they would tell you that the business judgment rule was already a rule in Texas, but the legislature hopes that by putting it on the books, it's going to make these lawsuits fewer than they were occurring before. Okay, so I'm going to talk about some case studies. This is the case of the Wise County Coal Company. The background of this case is that Charles D. Cates owned some valuable coal land near Decatur, Texas, and leased neighboring coal lands. He had exclusive rights to mine the coal for 25 years as long as he started work within 2 years. That's an important fact. The land was rich in coal, but it was far from the nearest railroad station, making it difficult to get coal to buyers. Cates didn't have the money to build a railroad or fully develop the mines. To solve this, Cates partnered with several businessmen, Stevens, Halsell, Lang, Greathouse, and Carpenter, to create a company called the Wise County Coal Company. The plan was for this company to own the land, build the railroad, and attract other investors. The company was officially formed in 1882 and had 9 directors, including Cates and the main partners. The company was valued at $250,000. Remember, this was back in 1878. That was divided into 5,000 shares at $50 each. Cates agreed to transfer his land and leases to the company, but the exact payment terms weren't settled at first. Shares were issued to the main partners and several others, but no one paid for their shares at that time. At first, Cates was supposed to get half the company's shares for his land, but since the company couldn't sell stock because there was still no railroad, people weren't yet interested, the main partners and Cates changed the plan. Instead of half, Cates would own 1/4 of the company. The others would receive shares based on the new agreement. The company also agreed to pay off a bank loan for Cates and lend him $5,000 secured by his shares and some land. The partners also promised to provide the money needed to run the mines for at least 6 months and to build the railroad from Decatur to the mines. Cates became the mine superintendent. Work began, but soon after, the other partners, who controlled most of the company's shares, started firing the workers. After 2 months, only a handful of workers remained, and then all were let go. The coal mining stopped. The tools and machines were sold off cheaply to one of the partners, and the railroad was never built. Because work stopped, Cates lost his leases on the coal land. The partners also stopped investing money or working to develop the mines. Cates believed the partners did this on purpose to ruin him financially and take his property for a fraction of its value. He argued in court that if the railroad had been built and the mines developed as promised, his shares would have been worth much more. Meanwhile, when Cates couldn't pay back the loans, well, you can guess the rest of the story. So there was a lawsuit. He wanted the court to cancel the shares given to the other partners, dissolve the company, cancel the loans and trust deeds against him, return his land and leases, undo the sales of his property, and give him $80,000 in damages. He argued that the partners broke their promises, acted to defraud him, and that he was owed compensation for the loss of his property and the value that was taken from him. This case illustrates an important lesson known as the business judgment rule. The rule protects those company directors and officers from being sued simply because shareholders disagree with their management decisions. If every shareholder was unhappy with the company's progress, could file suit whenever things did not go as planned, companies would be constantly tied up in court. And so that's what the state of Texas does not want now in the year 2025. They want an environment where businesses can feel free to innovate and invest and take some risks without the fear of being sued by their shareholders. In this dispute, it was claimed that the director spent about $15,000 to start off the mining operation, hire workers, buy machinery, and put Cates in charge. But the court found there was no fraud, no oppression, no abuse of power, or illegal actions by the directors. And so the courts were reluctant to interfere with those decisions. Some other lessons learned that you may have guessed while I was telling the story is that business deals should be clearly written with all terms agreed up front. Don't get started until the deal is on paper. And trust between the owners, the partners here, is essential, because when broken, it can lead to major losses and lawsuits. So you want to know what they're thinking. You want to know how they think. You don't go into a business deal lightly. Hire an attorney to help you evaluate and decide whether it's a good deal. And if the lawyer tells you it's not a good deal, don't get mad at him. Just find another better deal. So like I said, I'm just going to repeat the business judgment rule so that we can learn it. Business judgment rule protects directors who act in good faith, even if their decisions turn out poorly, unless there is fraud or abuse. And in this case, Cates, that's the name of the gentleman, did not prove that there was any fraud or abuse. Okay, let's look at another case study. This is a family business dispute in the salt industry. The Weber family established a salt mining business in Texas in 1926. Over time, the business grew and branched into several companies, all owned and operated by members of the family. The two central companies were Texas United Corporation, the parent company, and United Salt Corporation, its wholly owned subsidiary. Other related entities like Texas Brine Company participated as part of the family business network. Ownership remained within the family with four siblings: Lloyd, Camille, Mary, and Roberta, holding equal shares in Texas United. Remember, that was the parent company. Additional family members and relatives also held shares in board positions, with several individuals serving multiple roles across the companies. Now fast forward to 2006. United Salt, one of the subsidiaries, saw an opportunity to acquire a salt mining and storage facility in, guess where? Saltville, Virginia. This plan, introduced by United Salt's president, James, included extracting salt and eventually using the underground caverns for gas storage. Due to potential liabilities, Texas Brine created a subsidiary, Texas Brine Company Saltville LLC, to assume the gas storage operations immediately after the initial acquisition at a price of about $3.45 million. Remember, this is fast forwarded to 2006. The acquisition was repeatedly reviewed and voted on by United Salt's board, that's the parent company, always passing by majority. However, Lloyd, a director and shareholder, consistently objected, doubting the project's profitability even after visiting the site and raising his concerns at board meetings. Despite this, the board approved the acquisition. When costs exceeded projections, the board investigated and hired an independent accounting firm, which found no fraud or self-dealing. Financial forecasts still anticipated a $46 million profit over 10 years, with each sibling projected to earn around $10 million. After the acquisition was complete, Lloyd filed a lawsuit both in his own right and on behalf of United Salt and Texas United. Remember when I said When a shareholder files a suit on behalf of the company, that's called a derivative suit. He alleged that certain officers and directors had withheld important information, acted negligently, and breached their duties, causing losses exceeding $7 million. He claimed vital details about future gas storage operations and related risks were hidden from the board, and that management provided misleading information to justify the deal and increase their bonuses. The companies argued that he lacked the standing to bring a suit on behalf of the company. So the court considered the lawsuit and considered the application of the business judgment rule and the requirements for filing a derivative suit under the Texas Business Organizations Code. The court used that other case that I just finished talking about, Cates versus Sparkman, as the main authority on the business judgment rule. It clarified that shareholders in closely held corporations are not required to initially plead the directors acted outside the rule's protections, such as through fraud, bad faith, or gross negligence, to have standing to sue. So a closely held corporation is one like this, family members, where there's not very many shareholders. The business judgment rule is a substantive protection for directors on the merits of the case, not a procedural barrier to bringing a lawsuit. So here's some key issues. You need to know how family businesses are going to handle disagreements, especially with decision-making controlled by a small group. The duty for company leaders to provide full and accurate information is important when making business decisions. The rights and challenges of minority shareholders in closely held corporations include the ability to seek legal remedies like filing this lawsuit. The court's approach to lawsuits by shareholders who believe management has failed in their duties to act in the company's best interest is an issue. This case, in particular, highlights the complexities of managing a family business with overlapping roles, the importance of transparency and fiduciary duty, and the evolving legal protections for shareholders in closely held corporations. It also underscores how courts balance the need for managerial discretion with the rights of minority shareholders to seek accountability. These are big issues, folks. If you're a director or an officer, or if you're an investor in one of these companies, a small business or a big business, you need to know about this new Texas law, Senate Bill 29. Here's a hypothetical. This is something that could happen. I don't have a case on point to say that it did happen, but what some businesses worry about is special interest groups that influence one of the shareholders to file one of these derivative suits because they don't like the politics of what the business is doing. So in this hypothetical, pretend or imagine that a group of minority shareholders of a Texas-based oil and gas company holding 2% of the company's shares files a lawsuit against the company in the Texas Business Court and the company's board of directors. Shareholders just happen to be aligned with the third-party environmental advocacy group pushing for reduced carbon emissions. They allege the board breaches its fiduciary duties by approving a $500 million investment in a new offshore drilling project without adequately assessing its environmental impact or long-term financial risks due to potential regulatory changes. Imagine that the shareholders claim this decision prioritizes short-term profits over the company's sustainability and exposes it to future liabilities, harming all shareholders indirectly. The lawsuit argues that the board's failure to conduct due diligence on environmental risk constitute gross negligence, attempting to overcome the business judgment rule, which protects the director's decisions made in good faith and with reasonable care. The shareholders supported by the advocacies group research cite studies showing declining demand for fossil fuels and increasing climate-related litigation risks. And so they seek to compel the corporation to take back the investment and adopt stricter environmental policies. Here's where Senate Bill 29 comes in. Because the business judgment rule has been codified, creating a presumption that directors acted in good faith, and the plaintiffs must prove bad faith or lack of reasonable care, the shareholders are unable to proceed with their claim, because part of the statute is that you have to have at least 3% ownership to allow a derivative suit in a publicly held company to get to court. Also, Texas Business Court, applying the business judgment rule, may dismiss the case if the board provides evidence of a rational business purpose, such as projected profits from the drilling project, frustrating the shareholders' efforts to enforce the environmental agenda. So if you're a shareholder, the hidden legal issue blind spot for you is that this could cause you to be frustrated in holding the company and its officers and directors accountable. It is a barrier that makes the business environment more favorable to those establishing businesses, engaging in investment and research and taking on risks that businesses might not otherwise do. So the governor and the legislature wanted to attract businesses to Texas so that they don't go to Delaware or Nevada or other places that claim to have more favorable business jurisdictions. So there's a couple of people I want to tell you about that think this is a good deal. And the first one is Senator Brian Hughes, who is one of the senators that sponsored this bill. He said that it would draw even more companies to Texas. It would help with economic development and bring jobs. The governor said, Senate Bill 29 provides business decision makers the certainty that sound business judgments made in the best interest of shareholders will not be second-guessed by the courts. So, if you're just tuning in, I've been talking about the business judgment rule in Texas. It's been codified under 2025 Senate Bill 29, which became effective May 14th because 2/3 of the legislature voted to approve it. As you continue to develop and grow your business, it's crucial to ensure that your business structure provides the protection and flexibility you need. To assist you in this endeavor, I recommend conducting a self-analysis using the Business Deficiencies Checklist. This tool will help identify potential areas of concern that may require legal attention. The checklist includes questions about the formation date of your entity, concerns about the strength of your business structure, and considerations for personal and business asset protection. If any of your answers indicate an uncertainty of potential issues, it may be beneficial for you to consult with a business attorney. A business attorney can advise you on whether amendments to your certificate of formation, operating agreement, or bylaws could enhance the limited liability feature of your LLC. As you know, or you might be learning for the first time today, attorneys at Marquardt Law Firm, a sponsor of our show, focus on business and estate law, including contracts, corporations, LLCs, and family limited partnerships. If you email welcome@marquardtlawfirm.com, that's welcome at M as in mother, ARQUAR, D as in David, T as in Timothy, lawfirm.com with subject business checklist, attorneys at Marquardt Law Firm will reply with the checklist attached. Then you can find out for yourself if you think changes need to be made. Of course, you can schedule an appointment by calling 210-530-4278. That's 210-530-4278. Or you can find out more information at marquardtlawfirm.com That's M as in mother, ARQUAR, D as in David, T as in Timothy, lawfirm.com. You can find this business deficiencies checklist. So I'm Todd Marquardt with Talk Law Radio. Listen every Saturday morning and Sunday afternoon. Check us out on podcasts everywhere, Facebook Live, and YouTube. I'll talk to you later.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law Radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the 10 Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.